అందరికీ శుభోదయం. గుడ్ మార్నింగ్ టు ఆల్ ఆఫ్ యూ. వెల్కమ్ టు లీగల్ మ్యాటర్స్ బై సాయిబాబు సుంకర. Justice Rakesh Kaintala of Himachal Pradesh High Court. In the case of Jagatram versus State of Himachal Pradesh, dealt with a case where an incised injury to the shoulder was caused, and the defense put a leading question that it was due to falling on an accidental fall on a wall. But it cannot be. Generally, you put questions like that. It cannot be in clear manner. Shoulder injury should not have been accidental. Please remember, in a case of 324 of the Indian Penal Code, Justice Rakesh Kaintala, he commented like this. Why I am making this video is, normally in the defense we will be putting questions like this only. Whether the injury was accidental or not. Whether when you hit a wall, then can it be caused accidentally due to fall or hit అని చెప్పి అంటారు. ప్రతి దానికి అది అడగకండి, ఇట్స్ నాట్ కరెక్ట్ అని చెప్పి జడ్జి గారు చెప్పాడు. సో ద కేస్ యూ కెన్ రిఫర్ ఇట్ యాజ్ క్రిమినల్ అపీల్ నంబర్ 459/2010 on 9/10/2025. In this Jagatram case, the judge held that this injury cannot be accidental, and it was supported by the doctor medical officer's evidence also. Before going into the legal point, let us understand the background story. Here, so a man and his wife, they were walking on the road. They were walking along the fields to the neighboring village. They were going to the neighboring village for distribution of some cards, distribution of invitations to their relatives. En route, accused Jagatram, he came opposite to them. Already there were disturbed feelings between them, but still the complainant greeted him. Em mama edo annadu. But the accused Jagatram, having a sharp agricultural tool in his hand, మీరు నాకు ఇది చేసి ఇంకా మళ్ళా ఫంక్షన్కి వెళ్తారా అని చెప్పి తప్పున he wanted to attack him, injure him on the head. But luckily, he played a defense role, as a result of which the injury was caused to the shoulder. Immediately, the villagers, they cried. This man also cried. The villagers gathered, but the accused fled away, giving some warnings or threatenings. So that's the case. Therefore, he fled away after threatening them. The villagers rushed to help him. They took him to the nearby house. From there, he was shifted to the hospital. Of course, he was there in the hospital and later discharged. At the time, while he was in the hospital, the matter was known to the police. The police came there. He gave a statement. Therefore, the police registered a case under 324 of the Indian Penal Code. They arrested the accused. They filed the charge sheet. Ultimately, as the evidence was proved beyond all reasonable doubt, he was convicted. Against the conviction, now came to the appealed High Court of Himachal Pradesh. Now here, the appellant, he says that, so he argues that the lower court did not consider. The victim was alone and wife was not present as per the evidence of so and so. ఎందుకంటే ఆ విట్నెస్ చెప్పాడు, భార్య ఉందా లేదా అనేది చూడలేదండి, కొడతాం చూశాను అన్నాడు. సో దేర్ ఇస్ అన్ ఎలిమెంట్ ఆఫ్ సస్పిషన్. సో దేర్ ఫోర్ the victim was alone present, but the wife was not present. Second, the recovery of the weapon is also doubtful. 27. Tarvata, the injury is can be caused by the so-called straight fall or accidental fall on the wall. Against to this, the state argued that no doubt there is a minor discrepancy because perception of the person differs from, ఎందుకంటే పర్సెప్షన్ అనేది మారుతూ ఉంటుంది. కొంతమంది చూడకపోవచ్చును, వైఫ్ని కూడా చూడకపోవచ్చు, ఎందుకంటే కొట్టింది వాళ్ళే చూస్తుంటారు, ఆవిడ కొంచెం పక్కన ఉండొచ్చు. ఇట్ ఈస్ ఓన్లీ మైనర్ డిస్క్రిపెన్సీ. మిగతా వాళ్ళు విట్నెస్లో చేశారు, కానీ దీంట్లో పెద్ద డైరెక్ట్ విట్నెస్ లేరు, ఎందుకంటే వైఫ్ అండ్ హస్బెండ్ డైరెక్ట్ ఎవరు లేరు. కేకలేసి కేకలైన తర్వాత వచ్చిన వాళ్ళు తప్పితే డైరెక్ట్గా ఎవరు లేరు. సో ఇట్స్ ఓన్లీ మైనర్ డిస్క్రిపెన్సీ అని చెప్పి వీళ్ళు చేశారు. కోర్టు ఏమంటుందంటే ది ఎవిడెన్స్ ఆఫ్ ది ఇంజ్యూర్డ్ షుడ్ బి టేకెన్ ట్రస్ట్వర్దీ. Evidence of the injured should be taken trustworthy unless there are compelling circumstances to disbelieve the same. Shall presume, unless it is countered, you have to presume that the incident happened. But here the prosecution has successfully established the case. Because no doubt the others may not be present. Injured evidence, interested person's evidence cannot be taken as untrustworthy. Basing on the facts and circumstances, అక్కడ ఉన్నారు, వాళ్ళ బావమరిదే ఉన్నాడు, వైఫే ఉన్నది, ఎవిడెన్స్ కాదని ఎలా అనగలం? నో డౌట్ ఇంట్రెస్టెడ్ పర్సనే, కానీ ఫ్యాక్ట్ అనేది చెప్పడానికి, రెలవెన్సీ ప్రూవ్ చేయడానికి ఎస్ దేర్ ఎవిడెన్స్ ఆల్సో కెన్ బి టేకెన్ ఇన్ అకౌంట్. అండ్ యాజ్ పర్ ద డాక్టర్ స్టేటెడ్ దట్ ద ఇంజరీ ఈస్ డీప్, ద ఇంజరీ ఈస్ incised cut. So definitely this cannot, and he also stated it cannot be caused by the accidental fall. Clear. So basing on the very famous case, landmark judgment, Dr. Satpal versus Delhi administration. So the denied suggestion does not amount to proof. ఏమయ్యా భార్య ఉందని చెప్పలేదు కదా, అంత మాత్రం భార్య లేదని కాదు. దిస్ ఈజ్ సత్పాల్ సింగ్ కేస్. సెకండ్ కేస్ దిలీప్ సింగ్ వర్సెస్ స్టేట్ ఆఫ్ పంజాబ్. సో ప్లీజ్ రిమెంబర్ ది సో కాల్డ్ injury cannot be stated to have been inflicted accidentally. And the interested witnesses, they cannot be weighed up because they are interested, because their presence, if the presence is natural, it has to be accepted. So trial court giving sentence is 100% correct. High court will not interfere. Appeal not allowed. Okay, please read the case law. Defense ke pramana upayogapade case, prosecution baga upayogapade case. Read it and enrich your legal. Thank you.